Hello, hello, hello. This is Johnny McGarvin. I'm coming to you from an undisclosed location. I have to behave myself today because I have Flamingo Patrol, but that's okay. We still have a happy hour and it's still going to be awesome. Let's do this thing, shall we?
All right. The next matter for the court is Tad Latuzik. That's file 25-43854-FY, set for a status conference. Do we have Mr. Latuzik with us? Are you doing this or is Ms. Hill got this?
Natasha's still hosting.
Ms.
I do
Hill,
not
you
see
have
that
anybody
name.
on? All right, thank you. No one has appeared to call the court. Mr. Latuzik has, I believe, failed to appear once before. That was on 8/14. And that was one of today's hearings, was a show cause for his failure to appear at that status conference on 8/14. He has failed to appear today again. So we will do a bench.
Judge, it looks like he's here.
God, I
All right.
sir. Oh God! I mean, I can't unmute this thing. Oh my goodness! I'm here, sir. I've been here since the beginning.
All right. I just didn't know that you were here and nobody responded. So I'm glad that you got in time to do that. So, Mr. Latuzik, the allegation against you is that you failed to appear on August
Now he thinks he's in the clear, but he's muted.
the 14th. What happened then?
Prosecuting attorney here in the courtroom with us. Or is it
Yes.
just me?
No,
Is
the
Mr.
prosecutor's here via Zoom as well. Why did you fail to appear on the 14th?
I was scheduled to have a preliminary, what they call a probable cause conference with the prosecuting attorney. My phone was destroyed by a young man who beat me up that one day. You won't want to talk about that. But I had no phone. So I went down there and I appeared in person to his office that morning to discuss the case. I was told by his staff that was impossible. They do not use phone in. So I did not have a phone at that point. Luckily, I had a second phone. I got that charged up that afternoon or the next morning. I called in. He said it wouldn't be a problem, by the way. That person, wonderful person. I called. I left a message. I called again in the afternoon. Left another message. That was a Friday. I understood that he was probably gone for the weekend, holiday weekend or something. So I called again on Monday. I called him 4 times. He finally picked up his phone, I believe on the 5th try, that I believe Tuesday or Wednesday. So we hadn't had our probable cause conference, and I thought everything got pushed back at least a week. As you've done here today, I've looked through the interest. You run a very good tight courtroom, sir. I'm impressed. I like being in your courtroom, if I have to be anyway, in a courtroom. The gist of it is,
I love you, Judge. You're the bestest.
I didn't know about the 18th or the 14th, excuse me, August the 14th. I was gone and working remotely. My fiance, a friend, had lost her uncle. She lost first, and a week later, she lost an 18-year-old cousin. So I was trying to support her and work remotely. I had no way of knowing about this August 13th. I didn't know, sir.
All right. Well, Mr. Latuzik, let me just say this. The notice of
Good Lord. Who wears such a thing non-ironically in public? Seriously. There's no excuse for it.
the probable cause conference that you were talking about on August the 6th was sent out to you on July the 30th, which is the same date that the notice for the felony status conference on August the 14th was sent out to you. And they were sent out to the same address at the same time. So the court did everything that it could to make you aware of the status conference. I will simply allow that a mistake was made. You have appeared in the past, so I'll give you the benefit of the doubt today and simply dismiss the order to show cause and consider that to be water under the bridge at this point.
Thank you, sir.
The next question that we have then is what is it that we're going to do by way of a resolution of this matter? So did you have a chance to speak with the prosecutor and resolve how we're going to do this case now?
If Mr. Fortnier is in the courtroom, he can explain, but my understanding in speaking with him, he basically asked me what my side of the story was. He had not reviewed much of anything in way of a report from the deputy or from his staff. He said somebody else had put together the report for him to review. So he was just starting to look at it. And I explained what had happened, which is exactly, 180 degrees opposite of what the prosecuting attorneys are. I've done 2 illegal things. I've transported a loaded firearm, improperly. I concealed carry, which is an untruth statement. So he was going to get with the officer that made the report that day. He was going to talk with him further on it, with this side or what's going on. I don't know why he can't do this by simply reading this guy's report. I mean, I filed a statement with regard to what happened to me later that day, but I don't think I suggested anything about the weapon that was confiscated. And really, they told me, the trooper told me, detaining it overnight and giving it to the sheriff's office.
Okay, Mr. Latuzik, let's just slow down a little bit. The question was, is there a way to resolve the matter? It doesn't sound like there is. So all of that detail right now isn't necessary. And I don't want you to make a statement that could be used against you later because we're recording all of this. So if there's no resolution, that's fine. And I'll simply ask the prosecutor what they request, and then I'll ask you what you request, and we'll set the matter for a court hearing depending on what those requests are. So Ms. Brucker, what would you ask of the court by way of a way to resolve this matter?
Judge, I just know he did do a pretrial with Mr. Fortier. It might have been today. There is an offer for an attempted CCW in this case, which would be a 2.5-year felony. If Mr. Latuzik's not going to take advantage of that offer, I think we'd have to set it for a preliminary exam.
All right, Mr. Latuzik, I assume that you're going to want a preliminary examination?
Sir, I asked that a question. Do I want a preliminary examination to go to trial? Absolutely.
All right, so we will. All right, we will set the matter for a preliminary examination, which would be the next normal process in a contested case. It doesn't sound like Mr. Latuzik wants to accept the prosecutor's offer, so we'll do that. Let me know today when that would be.
29th in the morning.
September the 29th, which is a Monday at 9 a.m. Is that going to be okay with you, Mr. Latuzik?
September 29th at 9 a.m., sir?
Correct.
That'll be fine with me, sir. I'll make myself available.
That would be an in-person preliminary examination that would be conducted here at the district court. And the prosecutor and yourself would need to be present. Do you intend to have an attorney with you at that time, Mr. Latuzik?
No, sir.
Are you asking the court for court-appointed counsel?
No, sir. Counsel.
All right.
Thank you.
And I will allow you to represent yourself, but you will be required to conduct yourself as an attorney would and be responsible for the same objections and admission of evidence and all those sorts of things as an attorney would. If you don't think that you're going to be able to do that, you would need to hire your own attorney, or you would ask to see whether you qualify for a court-appointed counsel. Although my understanding is that you're employed for full-time, so I doubt that you would qualify for court-appointed counsel. All right, we'll simply set this matter for the preliminary examination. I will see everybody ready for prelim on September the 29th at 9 a.m. All right, thank you. That's all, sir.
It does call the case of the estate of Earl Samuels II versus Jonathan Samuels.
Good afternoon, Your Honor.
Good afternoon. Your names, please.
Jonathan Samuels.
All right.
Steve Magus, Your Honor, attorney for the personal representative of the estate of Earl Samuels, Tim Flynn.
Okay. couple of things, and the reason that the court set this hearing. We have checks in place to try to make sure that documents aren't filed. I'll say in violation. I'm not saying that using the word that it was intentional necessarily. All of which includes the court officer, all of which seem to have not taken place. But the question for the court is frankly, I don't know that this writ should have issued in the fashion that it did. Maybe for not, but ultimately, but it should not. First question I have is the documents we had indicated that the writ was executed.
Yes, John.
Okay.
Without any notice.
Well, there would have had to have been notice because there should have been 72 hours notice.
They put a notice on the house, but he knew that at the time I wasn't staying there. He knew where I was. He didn't email me or
Who knew?
Attorney Marcus.
Well, all of the orders of eviction, which I sign and send out, and I'm the one that does it, there's a 72-hour posting. So it's posted, it won't be executed for 72 hours. Are you saying that didn't happen?
I imagine, no, they put a notice on the door when I saw it, when I went there afterwards, the notice on the door was dated more than 72 hours before the action that they took. So they did that, but the point is, Attorney Magnus has been in communication with me about a lot of things. Deliberately didn't tell me they were doing this. He deliberately didn't tell me they were towing my cars. It's representative of how everything has gone and his lack of respect for my devisee ownership right, and the fact that I told him from the first moment I talked to him, now nearly several months ago, that buying the farm was the most important thing to me, and he's done things which have very much hurt me and my ability to follow through on that. So this is just one of, he also locked me out of the house where I was staying at the time on June 30th, my parents' house in Farmington Hills, without notice. So he has a pattern of doing things just that are easy for him. And then he tries to say I wasn't staying there all the time, even when, as he saw, my things were there, my food, my computers, my documents, my, I mean, so and now they're saying that I like never lived at the farm. I did live at the farm in the past. I mean,
there's a big story here that we could take up the rest of your afternoon, and then some with regard to the administration of Jonathan's parents' guardianship and conservatorship, and now their probate estate. I'll try to keep it on the main points that relate to this case. The property that we're talking about here has been approved for sale by the Oakland County Probate Court.
Got it.
Before the probate estate of Earl Samuels was involved, a judgment was issued that advised Jonathan, I think it was the end of 2023, that any personal property that he wanted to remove from the property, he needed to remove by, I think, the 12th of December, 2023. We had several of these judgments with regard to estates and properties, okay? And I applied for orders of eviction on all of them, just to simplify the contingency that Jonathan has a pattern of anytime we try to sell a house, he says he lives there and he moves in. So I learned thereafter about there's potentially a court rule that says it has to be 56 days.
Yeah.
It wasn't that intentional. It wouldn't be the first time I've learned in real time about a court rule. But the reality is Jonathan doesn't live there, and he's using this as an opportunity to effectively appeal the probate court's decision to allow the sale.
which was based on misrepresentations, many of which by Attorney Magnus.
All right.
I believe.
So I'll let you talk, sir, but I'm not
I'm sorry, Your Honor.
going to have parties interrupting. Let me just say this, I'm not going to get into anything that the probate court does. If I wanted to be a probate court judge, I would have done it. So I'm not going to do that. All right. The issue that I have in this case, and like I said, there are a number of checks in our system, all which failed, is that there would have needed to be a hearing prior to the issuance of the grant. It becomes a little bit more concerning based upon the documentation that I received today and reviewed, that the defendant does not reside at that address. That's what I received today from, I think, the individual who is the conservator of the estate or the personal representative, which maybe means that the issue is moot, or maybe not, because, sir, you're claiming you reside there.
I'm claiming that I resided there in the past, that there's things of mine there, and that they still need to go through some process because I have rights. Because especially now that there is an estate and I'm a 50% advisee, that they can't just, without any notice, decide to try to have something enforced that's actually a totally separate action. Nearly 2 years ago, it's obviously no longer the conservatorship, and I didn't have any ownership right then. So it's, the law is actually that ownership passes at the time of death. It's just subject to administration, and then it gets backdated, sort of. So I have a legal interest that I did not have in the farm almost 2 years ago. And in fact, I told, as I say, Attorney Magdis how important it was. And he refers to me not moving things out. Well, what I told them nearly 2 years ago was I was determined that the farm wouldn't leave the family. So Dad didn't want it to leave. He had testamentary capacity. All of this has taken place because people don't respect even the proper procedure.
Sir, I'm just gonna stop you, because you're getting into issues of which this court doesn't have jurisdiction over.
Right, but it did have and there's actually some question of whether it even has the authority to evict someone in a situation like this. Some things that I was studying today, and I actually filed something additional with the court because of my ownership interest as an advisee, that it's not even necessarily subject to the same landlord-tenant eviction procedure as Attorney Magdis had enforced inappropriately. So it's complicated. And Attorney Magdis and now my sister's attorney want it to be simple. And it's representative, as I was starting, of many things that have happened over the past 4 years. Because my parents were clear on what they wanted. My dad was clear on what he wanted for the future. And for the farm to be sold like this is horrific. And the fact that...
But sir, just stop for a moment. The sale of the farm, as you're indicating, again, is not something that is within my jurisdiction.
That was my next sentence. But your signing this order was an essential step in them selling the farm. So,
and it may very well be, but what they do with the property after an eviction, I'm not part of it. I don't know. On the numerous cases I've had today, there are eviction orders that are.
For those of you who don't know, Bama Mike has got a fantastic Eric Martin video of him getting pulled over on the moped in the winter in Michigan. We'll probably do a therapy session on it later, but I would definitely recommend it.
Are issued, what then the owner or the person in charge or with authority over that property does, I don't deal with.
Of course, Your Honor. I'm just asking for you not to issue an order of eviction in this case, especially because there's multiple reasons not to issue it. Both the fact that, as you say, they didn't follow the regular rules the way they're supposed to, initiating a new proceeding if they were going to argue that eviction was the
Well, they wouldn't be required to issue a new proceeding. There would need to be a hearing prior to the issuance. But then the information that I've subsequently received may have the ultimate result of that be moot. Because the real issue is at the point, there's a time limit from the point of the judgment to the issuance of the writ, and then how long the writ then has to be executed. There are two 56-day periods. Here, the first one, in terms of having a hearing, wasn't complied with. The question becomes, at least in my mind, is do I order you restored to the premises? Or do I not order you restored?
I would say it's simpler than that to just vacate or stay your eviction order because there's.
Can I just say this? By what you're telling me, and I don't know this for sure, but certainly the information that I received was that you were not residing at the property.
Not.
Things you're saying to me right now lead me to believe that you weren't residing at the property and that there really hasn't been any harm by the execution, because you keep talking about something that has occurred as though it hasn't occurred.
No, they definitely caused harm. They already towed my vehicles. They broke into the house. They didn't give me any notice that I needed to work to remove, because they're actually, even though the house, I mean, there's things of significant value there that Attorney Magnus is not aware of.
If it's helpful, Your Honor, with regard to the substance past the procedure, he can have everything in the house. It's a hoarder house. He can't even open the door. It's actually dangerous, which we're a little bit worried about, but if he's willing to waive liability, he can go in and take whatever he wants. What we're trying to avoid is him getting back in there, claiming he lives there and stopping the pending sale.
Okay, so let me just say this. Although the eviction was executed, there was property that was not removed from the premises as of yet.
The only property that was removed from the premises is 2 derelict vehicles that were towed and are available for Jonathan to pick up.
Okay, but those were on the outside. Those were on the premises, but not inside the house.
Yes.
But as far as things in the house, nothing was removed.
Nothing was removed from the property.
Correct.
Okay, that's
not true.
makes it
They
easier for me.
moved things out on the front yard. They took some things. I mean, I wasn't there, but it looks like they took some things away. Because they scattered stuff on the lawn and out by the curb.
Here's what I'm going to order at this point to try to correct the 56-day issue, as well as to try to address whether or not then there's sort of this clear path to the estate doing what it wants to do. I'm going to set a hearing. So while it's after the fact, the very fact that things have not been removed is fine. My determination will be whether to allow the execution of the writ to stand. And in that respect, the property inside, you can let him in or not, if that's the way I rule. Or that you would at least for a time period be restored possession of the premises subject to the hearing and then the court's issuing of a new order of eviction. And that's the best I can do to kind of remedy the circumstance. Quite frankly, it's a little bit easier than I thought because stuff hasn't been removed. So it's easier in that respect. It's also maybe easier in a certain respect. I don't think you were residing there. So it's not like I took, sir, please.
I'm sorry, Your Honor.
It is not as though there was a, for lack of a better term, a household that then is completely taken out, and this is a different scenario. So we will have the hearing, and I will either allow the execution to stand or put it back in. That's how I'm going to handle this. And so, when's my next?
The time issue though is,
I'm sorry, sir.
that I would have, if he would have followed things, I would have had more time to deal with. There's things there that would take me some time to move.
But sir, okay, let's just go with your hypothetical. Had that happened, they would have requested a hearing because it's afterwards. Let's say at that end of that hearing, I permit the issuance of the writ. Okay, just hypothetically, let's say we had gone through that whole process. And let's say they brought their $15, they brought the writ or the order of eviction in, I sign it that day. They get the officer to go out there, post it. You're going to have the same time frame. You're going to have those 72 hours prior to then the execution of the writ. So in terms of your argument regarding time, it's not an argument for the court.
Wouldn't there have been time before the hearing that I would have been notified of the upcoming hearing?
Right.
So that's the most significant time. Because
Are you listening to anything I'm saying?
I definitely am. You said that the order of the writ would be 72 hours, but I'm talking about before that, before you would potentially issue the order, the time between being notified of the hearing and actually having the hearing. And I don't know.
Okay, so here's what I'm going to do. Listen real carefully. I think counsel gets what I do. I'm going to set a hearing. Normally what the hearing would have been, had it occurred in its order, would have been a determination as to issue the writ or not. I will set that hearing, although it's seemingly after the fact, there isn't much harm or any harm because I don't have a household that's displaced. What I really have is a circumstance where they've taken possession of the premises. Things have not been removed. And then I will make that determination as to whether or not that writ will stand or it will not stand. You follow that?
Yes, Your Honor. I just thought that there's requirements of notice before such a hearing.
I am about to set a date and that will be your notice.
And what would the date have been if they just started fresh?
Sir, yeah, okay.
I'm sorry.
I'll give that to you. Hold on one moment. What's my next day, 16? Okay, so here's what I'm going to do. I'm going to set it for the 16th. Okay, in person at 9 a.m. Now, we're on the 5th. So that gives you now, from the court's final ruling, 11 days. So your question is whether or not that in some way penalizes you. Actually, you benefit from it. Because had they filed the motion or the request for hearing prior to, had they mailed it to you, they could have had a hearing in 9 days. If they had personally served you, they could have had a hearing in 7 days. Here, that's the notice you would have gotten. Here, you're getting 11 days.
Okay, Your Honor, but would that have been a hearing based on the previous filings? Because that's my basic contention.
Previous filings of what?
That led to your judgment in December of 23.
I don't know what that means.
They're attempting to continue something that isn't So I'm not sure how the procedure would work if they didn't have the December of 23 record and your,
You are truly not following this, are you?
I'm sorry, Your Honor, I'm just thinking.
No, you're creating difficulty where there is not difficulty. And you're not listening to what I'm saying. Because what I'm telling you is that on the 16th, I will make a determination as to whether or not the writ stands, or whether or not that writ is then the execution thereof is squashed and you're restored possession of the premises.
Okay, thank you, Your Honor.
That is the same decision, quite frankly, that had they filed the 56 days and had they filed for the hearing, that is basically the same determination that I would have been making. Could they have the writ, or do they not get the writ for whatever various reasons, may have to do something else?
What's the reference to 56 days? That's what I don't understand.
There are two 56-day periods in landlord-tenant law. First is that a judgment must issue within 56 days of its rendering. Has to be signed. The second is that a writ, well, actually, that first one isn't really necessarily a 56 day. After the judgment, the writ of restitution or order of eviction cannot issue 56 days, more than 56 days after without a hearing. And then once that issues, that the second 56 days is that writ must then be executed within 56 days of
It's okay. That's what I didn't understand. Okay. I thought it was after. It's within. Okay.
What's it within?
The 56 days that you refer to are periods within which something must occur. I thought they were periods after.
Okay, so that I'm not going to sit here and go into some huge legal argument with you.
Okay.
It's the 56 days where things can happen automatically without court intervention. Let's do it that way.
Thank you.
All right. So while that happened in this case, I am the writ was not executed in its traditional sense because things were not removed from the premises. And I would take counsel's representation as not for the court. That has not occurred. So then the question becomes, really, just to break it down to you, make it easy. I'm going to have the hearing on the 16th for a determination as to whether or not I allow the order of eviction to stand or whether or not I vacate.
Thank you, Your Honor.
So I will set that hearing September 16th, 2025 at 9 a.m. That will be an in-person hearing. Provide to the court whatever you wish the court to review prior to that time. And I will also review what I need to at that hearing and make my determination. Thank you,
Things
Your
will
Honor.
still be here, or will eventually you be in Saline?
Pardon?
Things are always going to be here, or will you eventually be in Saline?
They will always be where I am. So I am here. So it will be here. I will let you know that on the 16th, it won't be in my courtroom C. It'll be in courtroom A on that date. Because it'll be
You're always here. Some things are out of the 14A4 in Saline.
14A4 hasn't been open for almost a year now, sir.
Okay, I'm unaware of everything. I'm sorry.
Okay,
Should I prepare an order, Your Honor, or will the court? Thank you.
we're good. We'll have to hear. All right, thank you.
Thank you.
Yes,
All
it
right.
is.
That was dangerously close to learn.
Recess.
I didn't know. That one got serious. So I have to cleanse the palate with the SovCit from Bama Mike. We will do Eric Martin eventually, but not now. That he just put that up. He's got a great Eric Martin video that's fresh over there. It's hot off the presses. It's fantastic. But I'm going to do one from a few days ago that I think is good. because we need to we need to dumber this down after that.
Hey, is the door unlocked? Okay. Are you the owner?
I'm his wife.
His wife? Okay. What's his name?
The owner's the bigger guy, Ryder.
Okay. What's his name? Hey. Do you have an ID on you? No. What are you doing in here?
I was kind of directed here.
By who?
I can.
By who? This is a closed business. You don't own this business. How did you get in here?
Yes, ma'am. I would like to speak to the internal affairs.
No, we're not doing that right now. Okay. Put your hands behind your back.
It's my business.
Hands behind your back or you'll get tased.
Yes, ma'am.
Do you understand me?
Yes, ma'am.
We're not playing around.
I have my bag upstairs that has my phone.
I'm 1095.
Is there anyone else upstairs? No, sir.
All right. And you're the owner, correct? Okay. Do you know this man? Okay.
I don't know. I don't know that there's no one upstairs.
Okay. Well, I have another unit coming. As soon as my partner, we'll go clear it. Okay. Okay. I'm gonna put him in my car. And then,
It's not a big deal. The jacket he's wearing is mine.
that is yours. Okay. We will.
It's not a big deal.
We will get that in just a
It's
second.
okay.
Let me get situated. Okay.
We walked. Have you gone?
I have not gone through. It was owners here.
I haven't-
Just wanted to
I
get
haven't
him
taken it.
situated.
And then let's clear the building.
Yes.
Want
His.
to do that? We'll clear.
Yes, please.
Can I show you my phone, please? It has
Alright.
my badge on it.
All right. Spread your feet. Do you have anything on you that's gonna stick or poke?
No, ma'am, I shouldn't. There's a small pocket knife.
That's fine. I'm not worried about pocket knives. That's fine. I'll let you keep your change.
My belt.
That's fine.
I mean, just like be careful. Be careful with those spike nails.
Mm-hmm.
Where's this business at?
Mm-hmm.
I have nothing to hide.
I'm good with him. All right. All right, get in. We're 10, 4, 8, 3, and 41 are clearing the building. He has no ID on him right now. I'm going to try to identify him. What is your name?
Man,
What is your name?
before I give you my
What
name,
is your
I'd like
name?
to speak to you.
No, nope. What is your name? Name. So this is how the process works. You either give me your name or you can go sit in the jail until the jail identifies you, which can take hours or days. What is your name?
Christopher
Christopher what?
Shane.
Is that your last name or middle name?
That's my middle name.
What is your last name?
Knight. K-9-G-H-T.
What's your birthday, Christopher?
March.
Look at that.
Do you have a Georgia ID license? Or do you have a different state?
Competent editing going on
Georgia?
there.
Okay, hold them. They're in there. They're going up to the top floor. The owner, he came in, saw him, and he said, I can't verify there's not people upstairs, so they're clearing it. 21, 41, and 83 are up there. So, yeah. 7-3 Central name, date of birth. Mm-hmm.
Any signs of anyone else or which way he came in or anything?
Did you just see him or? Okay, so I almost never come in the back door, but I was at Waffle House, so I came in the back door and it was propped open. And so I assumed my manager was here because I came in, I said, Kevin, my manager's name. Yeah. And no one answered me, so I came in and I saw he was literally just standing here. Yeah. Wearing all kinds of things from the store.
You haven't heard anything else?
Well, that's what I'm not 100% sure. We have an upstairs and I thought I heard something up there.
Okay.
I know it should be up there.
Well, we'll go through and clear everything real quick if you want to just stay here towards the front door just to be safe until we do, all right?
Okay.
Get them on the phone. Tell them not to come in at all, please. All right.
Clark County Police, anybody here, make yourself known.
Can't see under. No. Check under the counter. I'll keep the big room here for you. Clear there.
All right, he's clear over here.
Clark County Police, anybody back here, announce yourself to me right now. Let me know. Take the order to the right. Okay, these are the stairs. So if you want to clear back to there, I'll hold this. Clark County Police, anybody upstairs, make yourself known to me right now. Again, Clark County Police, you're upstairs. Make yourself known to me right now. Take this. Yep.
Is this the SovCit den?
Probably, because I didn't see any stairs up front. He said the back alley door is what was propped open though.
Who said propped up the guy?
The manager owner guy.
All right, Christopher, listen up. I got to read you something. You have listen to me. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning, if you wish. Even if you don't want a lawyer now and agree to talk with us, you can at any time change your mind and ask for a lawyer or stop talking with us. Having these rights in mind, do you understand each of these rights if I explain them to you? Yes or no? Yes? Yes or no? Okay, do you understand these rights? Okay, having these rights in mind, do you wish to talk to me now?
The only thing I wish to ask
Yes or no? Having these rights in mind, do you wish to speak to me now? Yes or no?
Yes, I do.
Okay, So, tell me, how'd you get in this building?
I only wish to talk to you about.
Okay, we're not doing what you wish to talk about.
Before I speak to you about anything like that, I would like to speak to my attorney.
Okay, so you don't want to talk to me. All right.
I do.
I love it.
Will you just document? I read a Miranda, and he said he wants to talk to an attorney first.
All right. Good. Talk to an attorney first.
He also said he's sovereign.
We're gonna go have that alarm real fast.
Okay. Let me see your shoes. Grr, like this? Nope, don't get out of my car.
I won't.
Yeah. Circular? Yep. All right, get him.
Okay, hey,
Who's taking this? You are.
I'm taking it because I got here first.
My iPhone.
Go have that alarm.
Move your move.
Right there.
What's up?
I'm trying to figure out what's going on, man. I was kind of like I own these guitars, so I can show you guys. I can show you,
Oh yeah, the other officer already mentioned that to me. So we'll take good care of your phone for you, okay? And then whenever you're able to get it charged up, you can do that. All right, I'm gonna go ahead and close the door for you here again. Just keep the cold air out. I think they're gonna be closed down for just a little bit longer. What?
my mom and my two godmothers are who raised me. They were all part of the lesbian like gay community, and you know, like I have no hate for anybody. You know what I'm saying? Like
Okay, well that's good. Neither do I.
like last night, all my friends came out.
Okay. Cool. Sit up for me, okay? I know it might not be the most comfortable, but I need you to stay sitting up for me. If you need to turn this way, right, put your feet that way, you can lean up against the door in the back a little bit.
Is there any way you can like or can you crack the window?
Are you hot?
Yeah.
Yeah, we can turn up the air a little bit for you, okay?
That was fun last night.
Let's see what we can do here.
It was a rowdy group.
There, little window cracks and the air's turned up too.
No, not yet. It's
All right, young man, you're being placed under arrest for burglary.
Yeah,
You
that's
also
right.
have multiple warrants out of multiple jurisdictions, just to let you know. Okay.
Clay Township, Net County.
Those book bags?
Yes, sir. Both of those. And I haven't stolen anything. Okay.
Okay, well, I can't ask you any questions, but I just want to point out that you're wearing their clothes. I'm sorry.
So there's that. This isn't good for you.
Okay. What kind of badge? Oh, okay. Okay, I'll go check it out. I'll be right back.
did you say a special idiot badge?
Special FBI special agent.
Oh, I thought he said idiot.
Criminal affairs.
Love it.
So apparently he thinks he's a special agent for the FBI.
He also says he's a sovereign citizen, so
Okay.
he can't be both.
Yeah, we're going to Supreme Court. because I'm going to sue the American government for allowing the church to continue to deceive us. They're allowing the church to deceive us for years. They've ripped my family off for decades. They've ripped the American citizens off for decades with their deceit. The whole Constitution is founded on deceit. The Vatican knows it's deceit. There is no God. There is no church. I declare sovereign, Cherokee, and Bohemia.
Saturn 3 Central. I'm en route to 600 with Christopher. Mileage is 113249.
I'm going to sue the Vatican. I know. I've done. I got the Rosetta Stone, John Jacques Rousseau, every bit of it. I've studied every bit of it. 13, 17, 20. Everyone's about to find out about it. Everywhere I go, I'm gonna bust everybody's religion just to be a douche. I'm really undercover. I promise you, ma'am. And I was directed toward that location. Those people have holes in their floor for some reason. I don't know if they just bought that property or not, but maybe the person before that property was the person that was there supposed to come see the stuff on the floor. Outlaws. Isn't that the Outlaws Clubhouse up top? Roadhouse? Support your local outlaw. There's a false wall. When you go into the bottom of that place, there's a false wall. Just so you know. So pretty much I was let in. You know what I mean? I didn't break into nothing. I can hang around as long as you will let me. And I never minded standing in the rain. You don't have to call me darling. Darling.
I might need to add that to my sound bites.
All I can do is keep her crying.
SovCit sing along.
So tired, so useless to complain. China.
Dispatch has been called.
China White.
Sit back in the seat.
I know.
Be quiet.
If the South would have won, we'd have had it made. I would have run for president of the Southern states. Mark A. Cooper. We own the railroads out there.
Sit back. Sit back in the seat. I'm not telling you again.
Because you got these handcuffs so tight, it hurts.
They're not meant to be comfortable.
Mark A. Cooper. I already know. We've already seceded. This right here is not, we're different from everything else. I already know. I figured all that out. China. White. videos and everything. If I am not going to go to jail for it. I have not done nothing wrong, really. Y'all ain't gonna set me up like that. Ain't no way.
He's gonna blow the lid off this conspiracy.
I've done nothing wrong.
He hasn't done nothing.
Department of Corrections have been infiltrated to the point of no return already. You got the Black Panthers in there running the show. You know, all the Alexander, Gordon Alexander, Warden
73
Foster,
Central. I'm at
Cynthia
600.
Nelson.
Last 3 of mileage is 253.
The Black Panthers have like infiltrated our government to the point of no return, and they're targeting the white community. Just so you know. And I'm not racist. I like black people too.
Hey, I've got one mail. Thank you.
But silent communication, microchips and shit. Thank you. That's us right there. See the sheriff's badge back on the back? That's me.
That door right there.
See what I'm talking about? That shirt?
Go.
My nation shirt?
Go.
I've never seen a cop car with that. I guess the same. You want the back of the
Okay.
shirt rather than.
Don't care. You can keep your thoughts to yourself.
It's actually safe. They're not that.
Don't care.
Thoughts. Okay, thank you. This way.
No, the sheriff or whatever. 14s.
Well, you're not the sheriff here, so deal with it.
Y'all know who tightened their affairs with China? Huh?
Who are you talking to?
I'm talking to him.
He's busy doing something. Stop interrupting him.
You want to hold that stuff for you so you can get on it.
What?
So if you don't want to hold it, I can hold it for you.
We're not going to drop it because we're just going to go right back in. And you can't pick it up. You can't carry it. Because you're under custody. You are under arrest. That is why.
Declaration of Independence. I feel like our government has become tyrannical.
Good for you.
like slightly autistic. I have a genius IQ, but I'm just not really social, social person. I'm analytically genius. And I'm an honest person too. Same thing. And that's not drugs. Those are to save people's lives. Because I had a friend who accidentally was like someone sold him some drugs, and there was supposed to be something else, but it had fentanyl in it, and they died. So I told my friend, I was like, hey man, I need all those fentanyl test strips you can give me, so that way I'm gonna go around and start testing people's drugs. And if they have any fentanyl in them, you know what I'm saying? I don't want that shit sold to anybody. You know what I mean?
Maybe you shouldn't do drugs.
I don't do drugs like that. I'm not high right now. But my religious belief system does tell me to indulge, and I do smoke marijuana.
Still illegal.
That's all depending on how you translate it. Because
No, still illegal in the state of Georgia. If you want it to smoke, then go elsewhere.
Athens is actually decriminalized.
No, it's still illegal in the state of Georgia. It's just a citation in the state of Georgia for a user amount. It is still illegal, so you can go to jail. It's illegal to possess in Georgia.
I didn't find any possession in there.
Did I say you did?
I mean, because I'm not on drugs. But there's also the ones that, like, if you're dying and I see you, like if I walk up on the street and I see someone sitting there like about to die, I can take care of them, save their life. And they just don't send a badge to anybody, man. I really do have my own badge. I learned the truth. That's why they were forced to do it, because I learned the truth. Our government has been deceiving us. The Vatican's pretty much running an extortion scheme. Like all those churches that get tax-free, they don't have to pay any taxes. All that stuff is a deception. There are a few tools that I have that have like that decipher everything, and it's obvious that they made it like Alexander the Great, and after the conquerors went, it proves that I'm wrong and the Vatican knows it's wrong. So they're really running a scheme on the world. There's no way churches should be taxed exempt. All those churches are tax exempt. Yeah.
Stop. I said stop.
Chug it.
Hello. How are y'all? Just a heads up, that shirt he's wearing, he stole it from the place he protected tourists. So, yeah. Ken downtown, he broke into the building and then damaged their property. And then he's wearing the shirt. And I didn't want to, he has some history of assaulting law enforcement. So I was not about to take him out of handcuffs just to get a shirt back. But I'll take that with me for evidence. And I'll go get his, he's got a bunch of change in both pockets and some dollar bills in this one. Burglary, second degree, and criminal damage. Hello.
Well, there you have it. As you can see, the Uber arrived bearing flamingos right at the end of the stream there. So I forced him on. I'm at a wedding. I had breakfast with Brecken this morning. It was very nice. It was very nice. For those of you wondering, here's a fun fact you may not know about Brecken. She's vertically challenged. She really is. I'm here to witness my nephew throw his life away this weekend. And that event happened to be right in Brecken's backyard. Well, not literally in her backyard, but in the town she lives in, which isn't that big. So there we go. So I'm definitely not bailing anybody out, as per usual. Thank you all for coming out. Behave yourselves. God knows I will. Flamingo Patrol. I'll be behaving myself all weekend. Yay, family. Thanks for coming out. I'll see you soon.